Whereas it is clear that the Constitution authorizes Congress to exercise personal legislative power over residents of the geographical territory subject to the plenary jurisdiction provided in Article 1, Section 8, Clause 17, and Article 4, Section 3, Clause 2, it is devoid of provision that authorizes exercise of such power over the sovereign American people of the several states of the Union. The perplexing nature of Section 1 of the 14th Amendment resolves when one discovers that less than 2 years earlier, Congress, on June 30th, 1864, in what is likely the most sweeping but effortless stratagem in history, before or since, evidently for the purpose of nullifying the unalienable rights enshrined in the Declaration of Independence and circumventing, evading, and defeating the jurisdictional chains of the Constitution by which they are bound, stripped the word state of its popular and ordinary meaning, as understood by all Americans, and used in all legislative instruments since and including July 4th, 1776, and convert it into a specialized term and define it to mean the same thing as its constitutional and statutory opposite, i.e., one of the territories or the District of Columbia. They do this under cover of the Civil War and thereafter withhold the new legal definition and meaning from the American people. The Civil Rights Act of 1866, the 14th and 16th Amendments to the Constitution, and every single other legislative act since June 30th, 1864, without exception, hews to the said new definition. The secret is concealed through the ongoing use of convoluted and essentially unfathomable definitions of state and United States, which exclude by deliberate act what people normally think of when they hear state or United States. For example, there are 75 different definitions of United States in the 50 titles of the United States Code, all of which, however, upon decryption, mean nothing more than 1. The District of Columbia, or 2. The collective of the District of Columbia and certain of the territories. The congressional stratagem of June 30th, 1864, results in the inversion of the American paradigm through redefinition of a single word state, i.e., a union state, into a term of art with a constitutionally and statutorily opposite meaning, which equates ultimately to the District of Columbia. Congress has no personal legislative power or jurisdiction in the former, and exclusive in the latter, and now nearly every American falsely believes that they reside in a particular state of the United States and are a citizen of the United States. Following in the footsteps of foolhardy, egocentric Britons before them, who will never be slaves, American wage slaves still falsely advocate that contemporary America is the land of the free. Section 182, and be it further enacted that wherever the word state is used in this act, it shall be construed to include the territories and the District of Columbia. The American people, pitted against each other in what is called ironically the war between the states, are not aware of Congress's alchemical transmutation of territories into states, and can be predicted to believe or claim erroneously that they reside in a state. The absurdity of said Section 182 is a violation of both letter and spirit of the Declaration of Independence and Constitution, and a breach of the equitable duty trust, and confidence reposed in Congress by the sovereign creators of the United States of America, as well as good conscience, operates to the injury of the American people, and therefore constitutes constructive fraud. Congress, via the ruse of June 30, 1864, effectively commandeer with malice aforethought, under color of law, via intentional production of confusion in the public mind as to the meaning of that certain novel term of art, state, extra-constitutional geographical territory over which to exercise absolute, exclusive personal legislative power and jurisdiction over the American people, and set about to extort from said sovereigns, as revealed in the title of said act, internal revenue to support the government and to pay interest on the public debt, for the aggrandizement as we shall see. The 14th article of amendment to the Constitution, passed June 13, 1866, and allegedly ratified July 9, 1868, is one of the most confounding pieces of legislation ever to issue from the halls of Congress. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. The novel so-called Citizen of the United States, introduced in 1866, is a subject and person, not a sovereign man, and a United States government employee, whose legal residence is the District of Columbia, defined territory over which Congress exercise absolute, exclusive, personal, legislative power and jurisdiction. In 1866, it is well settled that Congress have no personal legislative power over the American people per se, i.e., those who make their home in one of the respective several states of the Union, only those residing in the District of Columbia or one of the other places and properties belonging to the United States. If the foregoing is factual and true, and it is, how can Congress in the 14th Amendment infer that all Americans, both those of the Union States and those residing in territory and property belonging to the United States, are the subject of rights and duties, i.e., persons and citizens, and ignore the sovereign standing of the American people? As of 10 years thence, in the revised statutes of the United States, 1873 and 74, Congress revised state, small s, to state, capital S, and territories, small t, to territories, capital T, but otherwise retained the same language, to wit, in pertinent part, Section 3140. The word state, when used in this title, shall be construed to include the territories and District of Columbia. In order to evade and defeat the provisions of the Declaration of Independence and Constitution, in their quest to secure, in behalf of their masters at the Private Bank of England, parent bank of the future private Federal Reserve, personal legislative power and jurisdiction over the American people, i.e., the creators and supreme political authority of the United States of America, Congress in 1864 changed the legal meaning of the word state to exclude all of the states of the Union and include only the territories and District of Columbia. The 14th Amendment is a Trojan horse because it appears benign, but operates to undermine organic law. The lack of constitutional authority to exercise territorial legislative power anywhere in the Union, or personal legislative power over any of the sovereign American people who reside there, is conclusive proof that 1. Congress is using the new definition of state in the 14th Amendment, and 2. All Supreme Court justices are complicit in the same constructive fraud and high treason for permitting a false constitutional amendment. Such is the magnitude of power of those in control of Congress and the judiciary. Congress commits the same constructive fraud as that of the Civil Rights Act, April 9, 1866, as well as high treason in passing the 14th Amendment, June 13, 1866, and all other legislative acts thereafter, a conclusion borne out in fact, increasingly so, as documented herein, to the present day, and adopt and employ policies of obscurantism and insidious incrementalism, through wholesale application of pleonasm and tautology in all official banking, corporate, state and federal, governmental, legal, and tax agency utterances of any kind whatsoever, so as to conceal the fraud and embark on a strategic plan to lure the sovereign American people into a contractual relationship with government that justifies a presumption of legal residence in the District of Columbia for the same purposes stated in the title of the original act of June 30, 1864, i.e., to provide internal revenue to support the government and to pay interest on the public debt. Between 1864 and 1894, Congress makes more than 60 attempts to enact a statute that justifies exaction of income tax from the American people, sovereigns over whom they have no personal legislative power. The judiciary disallows each for unconstitutionality. The Federal Reserve Act, like its antecedent in England, is slated to introduce fractional reserve banking in 1913, but Congress have yet to devise a tool that will induce the American people to volunteer to pay income tax and yet still pass muster with the Supreme Court. On February 3, 1913, Congress enacts the 16th Amendment to provide revenue from taxes on incomes in the several states, i.e., the territories and District of Columbia. The Constitution authorizes Congress to impose an income tax, if they so choose, on persons residing in the territories and District of Columbia, the newly defined states. However, whereas Congress and the judiciary know that states means only the territories and District of Columbia, the American people do not. Today, the controlling definition of the term state in all state and federal legislation means either 1. The District of Columbia, 2. Guam, 3. American Samoa, 4. The Commonwealth of Puerto Rico, 5. Virgin Islands, or 6. The Commonwealth of the Northern Mariana Islands, and no other thing, the collective of the foregoing states. Each of the so-called 50 states, sans, of the Union, example, Mississippi State, California State, Nevada State, etc., foregoes its proper name and goes by state